Good afternoon, evening, morning, whatever, night. Hello, not legal advice. Please like, subscribe, share. Um, I'm going to talk slowly. I just I've worn this shirt before. Let me see if I could tilt it down a little bit. But that's my shirt. I'm afraid not. You like that one? Okay, that's great. That's the best humor you're going to get here, of course. What I wanted to do, I promised to do a update on GTII, so I will do that. I did that for two reasons. One, because I'm trying to update you on a regular basis so you all kind of know what's going on. And two, because those kind of events, I think, push other people to act. So that's the intention. So it's always dual motives, trying to obviously keep everybody updated. And hello out there, Chris, Market Watcher. I'm looking over here. Rondell, Stony Bones, Charlie M. Lee, Jason. Hello, everybody out there. And whoever else I didn't call, hello to you too. You count a Grand Rising's up there too. Let me go to the top. I don't want to omit anybody. Oh, yeah. And hello, StreamYard too. StreamYard is, by the way, the most consistent in terms of attending these particular live streams. So thank you, StreamYard, for attending and being a GTII fan. I set these up at a regular interval. I was going to actually do it earlier in the week, but I had reason not to do it earlier. But I like to do it to keep everybody updated as to what's going on, plus or minus, and also to obviously put pressure on somebody if they have to do something that they know that there'll be a live stream that'll talk about it. That might encourage work to get done. So that's kind of the double-fisted approach. May not be received well by the recipients all the time, and I understand that also. So before I go into more detail, I decided for anybody who doesn't want to hang out more than like 2 or 3 minutes, or whatever, I'd give you a quick summary of what I'm going to say, and then you could split if you don't want to hang out for the rest. So I'll try to do it in the future to be more kind for everybody's time. So first of all, it's not legal advice, obviously. So basically, the receiver's report, received the receiver's report about 12:30 my time. It's about 30 minutes ago. I just glanced at it, have not had a chance to read it. It's here. Can you see it somewhere? Well, anyway, I'm waving it around. It's 44 pages long. So I have not yet seen it. We will together take a quick look at it. And JR and I are doing a live stream tomorrow at 7 Eastern, and we will go over the contents of the report in great detail after I have a chance to read it and review it. But one of the reasons why I didn't do this live stream before is because I was waiting for this report to be done, and thankfully it was done. And I appreciate the Receivers Council who prepared this document or helped prepare the document for their assistance in getting it done. So before today, so anyway, Receivers Report. I'm supposed to give you a summary. There's the motion regarding shares. So previously I talked about the motion regarding shares that hadn't been filed or prepared. As of today, my understanding that a draft was circulated, so it's ongoing. So now it's actually something's been prepared, not yet filed. I would guess that prior to May 27th is the next hearing in court, which I will attend also. But prior to that date, I would expect that motion to be filed. And kind of originally we talked about things that would be required to be done as to getting the transaction done, not guaranteeing it getting done, but as to what would be required. One was the prior motion about claims, anybody have a claim, get it in now or forever hold your peace. And this second motion regarding the shares is the other thing that's required before there's any chance to consummate the transaction. So that should be forthcoming since the draft came out today. And again, I'll discuss that in more detail, but that's good news there. There's a status conference on May 27th and hearing on a couple of motions, one being that claims motion, which will set the date, and I'll explain that, and one being the motion to withdraw, which is the mechanism by which I am now appearing on my own behalf, with obviously the interests of everybody at heart. Then there's the audit, and it's referenced in the report. So the audit, all the information is complete. The only thing they're waiting for is for sign-offs by 4 or 5 attorneys who, in my language, this is not what the report says, but it appears to me that there's 4 or 5 attorneys who are dicking around for some reason. I will speculate as to the reason when we get there, but that's what appears based upon what I see in the report. If they don't sign off, then I think the suggestion is there'll be a court intervention, and they'll try to get the court to order them to sign off. So the auditor won't sign off on the audit until they get these people to sign some kind of confirmation of either numbers or something like that. I'll explain it in greater detail before, but all the information otherwise has been obtained, so it's done. Other than that, so we're at the end. It seems like very near the end of the audit trail, and I think they got some kind of extension also. But we'll look at it when time comes. And those are the major topics. If you want to split, you can go split. But otherwise, if you want to hang out, we'll talk about that. We'll also talk about Alpine. They filed a reply brief in the Supreme Court, and we'll talk about trading a little bit. So that's it. And if you want to hang out, then great. And if not, and you got better things to do, then that's fine also. So now I'm going to continue. Before we continue, I wanted to talk about something that really was amazing. You know, when I was growing up, the cockroaches were so big that we called them roosters. I don't know if you had that experience or not. And, you know, I'm a dog person. You could see because on my site, I have 2 dogs, Ridgebacks. I only have one now, unfortunately, because one died recently, and I love Dante. But Aggie's good too. Anyway, living with a dog is 90% following each other around, watching each other go potty, and wondering what the other has in their mouth. Isn't that true? And last but not least, I got a double here. Bigfoot often gets confused with Sasquatch, yet he never complains. And last but not least, but related to the prior one, Sasquatch is what Bigfoot gets if he doesn't clean his Yeti. All right, that's the 2 combos. I hope you really enjoyed those. Fantastic. Those are fantastic jokes. And I apologize to Big JR. I think I misread his joke last week, and I think the audience liked his joke better than mine. Just as a throwaway, Doug Seafew, who was with Virtu Capital, I think it was last year. Yeah, last year, more than a year. No, 2 years ago. Wow, 2 years ago is with regard to MMTLP. Somehow he was watching my videos, and rather than commenting on the the content, he said he hated the joke. That was what his comment was. And as a result, his team lost the Stanley Cup Finals that year. And as you know, this year he was suspended by the NHL for making inappropriate comments, I guess, on social media with regard to MMTLP in that community. So, and I ribbed him about that when he put that on. You know, above all, that's all he can say is a bad joke. He couldn't, anyway. Just so everybody's aware of that, I will take full responsibility for that. And I started the ball rolling because of my wonderful jokes. So thank you. You never know where a good joke or a bad joke might lead you. It might lead you to get suspended from the NHL and perhaps maybe get you in trouble with the SEC. We'll see. Anyway, so got the receiver's report today. I had kind of been hoping and expecting to get it. I'm now going to be representing myself. I think I mentioned that. So the difference is now I can contact the receiver directly. In the past, if I tried to do that, they don't have, ethically, they're not supposed to respond to me. You can waive that, and my counsel can, but it makes it kind of a difficult position for them. And I understand their concern about that. So now there's no concern. So as opposed to the prior where I would communicate with our counsel, the plaintiff's counsel, and they would communicate with the receivership counsel, and now I can do it straight. And I have since over the past 10 days to I have communicated. So we have had some direct communication. So that's good. Again, to those who are plaintiffs, you will get, and you are able to get direct communication from Alex and the law firm that represents you all. And of course, you can listen to me and I will tell you what's going on. And I will be there in court when needed, also physically in court. So we can go from there. It was kind of interesting in my communication with the Receivers Council. I found this funny today. I didn't necessarily find it so funny at the time, but that's the way it goes. Is they question my motives because they don't think they're monetary. So they thought that nobody can do something. In essence, they said they were concerned that my sole motivating factor is not monetary. I was appalled by that, but that's so be it. I held my tongue. Let's just say that. Obviously, if you examined my ledger with regard to MMTLP and GTII, there's no monetary encouragement. And JR would tell you, little JR would tell you that too. Obviously, he and I talk about this a lot. So anyway, but I found it kind of interesting that the Receivers Council kind of had that view of somebody that was actually doing something for the right reason. I thought that was interesting. And again, I would sign, I'd agree to a lie detector test that I'm not getting any financial benefit or I'm not benefiting anybody by my actions financially or have any connection or agreement with anybody. In fact, I'd like to do a lie detector test. So if anybody has anybody who can do a lie detector test, I would like to do that and say, and they could ask me the question. They could be specific because that would be fun. That would be a good live stream. Don't you agree? If I'm hooked up to a lie detector and they do it, and what happens if it doesn't test accurately? Also, that would be really interesting. So if anybody has a lie detector connection and they're telling the truth about it, then contact me. So anyway, the Receivers Report talks about the audit. First of all, and the Receivers Report was literally filed. The stamp on it is in Pacific time. It was 12:10 p.m. I got it probably around 12:30ish. So I appreciate them. By the way, I appreciate the attorney that I had communication with, Dylan of that firm. I appreciate him getting that to me quickly per my request. So thank you. I appreciate it. He's the one also that had prepared the prior motion that was filed as to the claims period, and I appreciate that he had gotten that done. I don't believe he's involved in the preparation of the motion that we got a draft of. Actually, I haven't seen it, so I'm just saying that I understand that there's a draft now that exists, but I haven't seen it, so I can't make any comments about it. But I don't believe he was involved with regard to that particular document. But the Receivers Report he was, and I'm kind of going through it. And again, I'm going to read it in greater detail, but I'm kind of go through like the highlights here as I look at it with you. So this is live, a live look. So it basically says that all the information for the audit is done, except there's 5 attorneys and they haven't signed off, and they have to sign off, or at least the auditor wants them all to sign off. And I'm just going to name the attorneys that are referenced here in the Receivers Report on page 3. Matthew Simon. If you know any of these guys, contact them and nicely. By the way, there was some, and I know like this is a very sensitive, GTI is a very sensitive subject. People are pissed at prior management. Join the crowd. I am too. But there are reports that people kind of get obnoxious when they contact these people. And unfortunately, that does us no good because it paints everybody as being a knucklehead, and it doesn't take our claims as serious as they should be. So if you're going to have contact with anybody, even if they're an adversary, do it in a non-confrontational way, and no swearing, cussing, and to the extent you can control yourself. If you can't, then don't do it. Have somebody else do it for you. But apparently, like there was an MMTLP. If 1 or 2 people do it, then the bad guys jump on that and they use that as a defense, even though it's just a distraction. Doesn't mean anything, but they use it. So be careful. you could reach out to people and ask for assistance. You could tell them what to do, but do it in a professional way. Anyway, so I'm just telling you there's these attorneys' names who haven't signed off. I don't know why not. Matthew Simon, Jack Fattel. By the way, Jack Fattel is the guy I had contact with in 2024. Time goes fast. It was about the filing of the 10K, I believe. And there was discussion about this acquisition that was getting done. As it turned out, I don't recall an acquisition being done. And there were also, if I recall, if it's, as opposed to filing that document, there was an extension. And then I recall there was a problem with the auditor, and interesting that he did not do anything. The next person is Robert Hantman. I know this guy too. How do you like this? This guy is like a New York attorney. I think he called me from New York a few times. I know at least on one occasion after we had spoken, he didn't know who I was, which was, whatever. I know he had some connection to GTII. I think he had a connection directly to David Reichman, but I don't know that for certain. I know he represented himself as a shareholder. I think he said he had, I'm guessing, 800,000 shares, so it wasn't insignificant. I think he even actually wished me well at some point in time. I don't remember the number of conversations we had. It wasn't a ton, a handful or less, I would say. But anyway, interesting. Next attorney that's referenced here is Terry Pham of Pham, Glass, and Rabat. And that was the firm that represented GTII early on. They're no longer there. I think they had to return their fees, or a portion of their fees, to the receiver. They're the ones, I think, who initiated the lawsuit against me for defamation, because I claimed, and I'm summarizing, that there were shenanigans going on. And somebody suggested that wasn't, besides, whatever the requirements are for the claim, somebody suggested that, no, there were no shenanigans, and you naughty boy. I think we all know that there ended up being a lot more shenanigans than I could ever in my most vivid dreams come up with. So that attorney represented the other side, and I mean the other side in the worst sense. And but anyway, they haven't responded. And the last one is Alan Pollock, maybe Pollock too, of Warshaw Burstein, which is a big firm. I don't know. So they haven't responded. So everything else is done except for these guys to sign off. Why wouldn't they sign off? Somebody might. So now I'm going to speculate some. This is the fun part. So, because if you don't do what you're supposed to do, then, then let's speculate why you're not doing it. So why are these attorneys not signing off a confirmation letter? Why aren't they? Is it because the information they're going to be signing off on is not accurate? Is it because they're concerned if they sign off on the information that it's already inconsistent with other information they may have provided? They might have provided to the feds. They might have provided to the IRS. So are they concerned about, fraud? Or tax fraud? Something they're concerned about? Are they concerned about having underreported income or not reported income? I don't know. But these are all questions I have. Are they just being cautious? Could be just being super cautious. Were they advised that way? Have they hired counsel and their counsels advised them that way? Are they trying to be trying to hide? All those are possibly in play. I think what's going to happen is, and I think in the short term, and that's kind of what the report says, is these guys aren't going to sign off. The receiver's counsel believes that's a violation of the order in which the receiver was appointed on the original part, and that the court can then order these people to certify. So we'll see. So I would expect that to be filed in short term being, within 30 days or less, because I believe that the Receivers Council knows the urgency of the matter. There's a reference to a bunch of subpoenas. I'm going through again, some of the Receivers report. There's a reference to, some of the money. I'll kind of look at it in more detail because it's kind of complicated. As of the writing of this, they've gotten back. Is that good English? What do you think? Gotten back. They've been able to reverse and retain, or whatever good words we can use, as of this date, 21 million shares. So of that amount, 275,000 from Cedars-Sinai, almost 15 million from Internet Capital, which was Warren Markowitz. Warren Markowitz was, I believe, counsel for GTI at one point in time. About 150,000 from Alexandra Zaloom, about 320,000 from Hamli Patel, and about 6 million from Dot8. Dot8 was that company that Justine Reichman was related to. So that's 21 million. The receiver says the total is 178, and they're ongoing, continued to try to recoup those shares. Now, if you recall, I think the discussion was, and this would be something I guess that'll have to be addressed on the road. There was a certain amount of shares that are required to be recouped. So this is a good start towards the final number. It's more than it was referenced in the last report. In the last report, I don't think the 14 million was referenced in there. I don't remember it being 21 million as a total, but I haven't had a chance to review this in detail, so who knows? One other thing, and it's referenced here, is that like in 2022, 2023, no business, no nothing. They sell a bunch of warrants. They raise $3.5 million, and somehow they spend a lot of it. 3.12 million in 2.5 years doing what? Buying furniture. I don't know, but that was an interesting point that I caught my attention as I was spending my 5 minutes of that. There's a section on stock volatility and how people, regular investors got screwed because that volatility, I think it's suggested by this, reflects like sales and purchases to insiders or family members who took advantage, while unfortunately people like us got screwed. So I think that's kind of an interesting point that wasn't referenced. And I think they also say that as opposed to maybe short selling, at least they attribute that. They understand the rumors. They actually reference it in here, at least I saw it. The rumors about the concentrated short position, et cetera, which is interesting because now it's in the record. So I appreciate that, especially for those like Ham who put that on the record about the concentrated short position. But anyway, so it exists in the record of this report, talking about the concentrated short position, et cetera. I think it just the rest is just dealing with historical purposes, entities that are affiliated, improper transactions. Since I didn't read the entirety of it, I don't know. But that's kind of what I look at this point in time. I'm going to go to the end where I haven't seen. Well, just says it's continuing. That they're continuing the information. It's dated May 16th. Yeah, and just basically saying the clawback of shares needs to continue. And I will give you much more detail about it. But the point was, I wanted the report to be done because I knew it was going to deal with the issues that were outstanding, and it does. But it's 44 pages long, so I'm not going to read it and spend 3 hours going through it with you. I'll try to condense it into a few minutes, and we'll go from there. But it's been filed, and the draft of the motion regarding the shares is circulating, and they're moving efforts towards getting that audit completed with those attorneys signing off or getting the court to do it. So all those are positive steps. And I think, if we get those steps done, then we are obviously, if this is going to trade, if we can get those things done, then we are basically have completed the steps necessary. I'm not a specialist in that process. So could it be turned down? Of course, for whoever knows, but that would have been completing like the prerequisites to get to that point. That's obviously great. That's positive news. I know that AI Versity was getting very impatient about the pace of some of the documentation. I know it's been communicated, or I believe it's been communicated. And I wasn't involved in any direct communication between the parties, but that's my understanding. A lot of frustration. But I think getting the draft today was a large step in getting them at least satisfied that the deal can be closed. I'm not speaking for them, by the way. I'm John Forrester can speak for himself. And he obviously did not provide me any information as to that, but that's kind of the way I see it. That's the prerequisite. So we have the status conference coming up on May 27th and a couple of hearings. So on the 27th, there's a May of this month. There's a hearing on the claims motion, which I think the court will probably grant, which will say as of this date forward, you have 90 days to assert your claim, and there'll be a process in which the claims will be evaluated. And that'll be through the receivership estate. And at the same time, the motion to withdraw filed by the law firm is representing plaintiffs as to me, per my request, will be heard. No objection. I mean, I support the motion. So that's going forward, and it'll be granted. And I will be able to speak directly to Receivers Counsel and appear in court as anybody else, and be able to speak when necessary, not to speak when not necessary. So that'll be heard on that date too. There's two dates actually. One's the 27th, one 28th. I think everything's going to happen on the 27th. That's what I'm expecting. I will be going to Vegas, traveling to Vegas to appear. I will be there. So we will do that. So that's that. Lis pendens. There was some discussion. I've talked about it before on this channel about I've wanted a lis pendens filed against both properties in California. I know that, and I think this has been public record before, and I think it's discussed that the David Reichman's property in Los Angeles, there is a voluntary lis pendens that was granted, and I think it was recorded according to what I understood. As to Northern California, there is not, as far as I know, and there's no action currently pending that would do that. And there's a question about whether Vegas has jurisdiction over somebody in California, although they probably do, and they may acquire it. But there's been some difference of opinion. And again, I mentioned this before, so lawyers can have different opinions, and they could use different cases and read them in different ways, and they might have different interests, and kind of like just setting that aside. So if you're acting as an attorney, you're representing your client's interests, but you also have your own interests. You don't want to get into trouble, do things that are inappropriate. You may have insurance that will have certain requirements. That's one thing. And then you have the client, like me, although I'm doing both roles here, but the client, they want it done. They don't really care about the specifics. So sometimes those conflict. And that might be the case with regard to the lis pendens, at least in Northern California. There seems to be, and this could change on both ends, there seems to be a disagreement as to whether you could or could not file it. I think you could. They think you can't. Their concern would be if they do it improperly, that they could get a expungement motion and they might be liable for legal fees. And again, they haven't told me this, but I'm this part. So I'm now speculating. But if you're filing a lis pendens, because I've done those plenty of times, if you're filing a lis pendens, you have to know as a potential risk, because the other side might be able to get rid of that lis pendens in a proceeding, motion, etc. And that if the prevailing party in that motion, as determined by the court, might be able to get their reasonable attorney's fees and costs. That doesn't mean all their attorney's fees. So just understand, when a document or contract says reasonable attorney's fees, what your attorney charges you is not necessarily reasonable attorney's fees. They don't always equate. Often the courts will cut the bills or the totals. But in this case, as to a lis pendens, so if you file, in essence, a notice that there's a case impacting a piece of real property in California, and it doesn't, and there's a legal proceeding, and you prove that and therefore that lien kind of is then canceled, then the losing party might be responsible for reasonable attorney's fees. And somebody might be concerned about that on the other side. But from my perspective, I wouldn't be, and I've obtained, this is my personal view, and again, people often disagree, but I've, under a constructive trust theory, not involving where somebody had title, I've had plenty of Liz penances survive. Doesn't mean that if they went up on appeal, they might lose, but my interest was on getting it filed to protect the property. And again, like I said, interests can be different. I'm the client attorney. They're an attorney for the receiver. Different interests. They don't owe me anything. They don't tell me anything special. So that's kind of how that is. So that's where the Liz pendants issue stands. It might change. They may decide in the future that they can file Liz pendants in Northern California. I might decide in the future they can't. But anyway, it was kind of a fair discussion and just about a legal question, differing opinions. So that was that issue. So those are the issues that still remain with regard to GTII. And again, tomorrow night, since I didn't have it, JR and I will have gone through the fourth interim report and we'll kind of relate what's in there. Last but not least, Alpine, actually two more things. Alpine filed a reply. So Alpine's the prime broker for GTII. It's referenced, by the way, in the receivership's report. I'll cite it when I get a chance to with JR tomorrow. But they were the prime broker at DTCCCCC. At one point in time said that they had a concentrated short position in GTII, and that's where that goes. They've had a bunch of problems involving misconduct. They've been shut down by various regulators and SROs like FINRA, DTCCCC, etc. But they've appealed it, and somebody's funding all these millions of dollars of litigation, and including, and this stuff is just like ridiculous, including, so they got, I like to review it, they got expelled and expedited, they got expelled. That expulsion was affirmed about 2 months ago through FINRA. So FINRA's trial department, we'll call it, they say, you're out. Their appellate department 2 years later says, you're out. They had 90 days to appeal to the SEC. That my understanding is they did. So it was about 60 days running. I don't know when that will be heard. There's no notice. I haven't seen anything. But that's ongoing. And there should be some proceeding before the SEC. Now, what's interesting about that is because there was a case in the Supreme Court last year called Jarkessi, which said if the SEC was seeking monetary damages involving common law claims like, fraud or contract dispute or negligence, that that the accused had a right to a jury trial. It's not a criminal case, but in a civil case. They had a Seventh Amendment right to a jury trial, and that the SEC system could not prevail. And here we are. If this case goes to the SEC, there's a bunch of damages that were awarded by the FINRA departments. So I don't see how the Alpine doesn't raise that and take this up to the Supreme Court. They haven't yet. Instead, what they did is they got an expedited expulsion, went through a bunch of appellate issues. We're back. It's ongoing again, the expedited expulsion hearings. But during it, they went to the Supreme Court and they filed their last brief, their reply brief this week, basically, contesting the constitutionality of it. And I guess trying to say that this case is like a typical case that, if it's something that's going to come up a lot, then the court's more likely to hear it. If there's a split amongst all the circuits, then the court's more likely to hear it. So they tried to paint it that way. Again, I don't think it's ripe. I mean, it's not really appropriate because they haven't been kicked out yet. They just say, and they cite a case in a Supreme Court case saying that, you don't have to actually suffer, physical, harm. It's the process. It's the deprivation of the constitutional process, which is sufficient. if I was the Supreme Court, obviously did not hear it this term, so the earliest they could hear it would be in October, starting in October of 2025 for the next term. I just don't think it's a great case because they haven't been expelled yet, and it's because it's a specialized proceeding. It's an expedited expulsion proceeding, but they are with the Supreme Court. But I do expect either prior to or subsequent to the SEC's ruling, if my suggestion is to them is do it before, because you can't get a jury trial before the SEC. So if you can't, they can't give you a proper hearing. The reason why you would have to go forward with that SEC is sometimes the Supreme Court would require you to they call it to exhaust all your remedies. So if you have things you could do in order but you don't, sometimes that's enough to defeat a request for relief. So sometimes, even if it's worthless, you'll do it because you have to, and they won't take the case. To kind of clarify something about the Supreme Court, it has original jurisdiction, which means like it's the place where the cases are filed on very few matters. Otherwise, it kind of takes the appeals of the highest courts, and sometimes lower courts, but mostly from the highest courts, and they're reviewing the lower court opinion. And that's kind of what they're doing, and usually pretty small amount of cases. So that being the case, I would think they'd wait for the other one, because the other one involves an issue that I think Jarkessi puts them in a difficult position, honestly, and because that would involve their actual expulsion, because they've been expelled now. And theoretically, they had to actually seek an appeal, or the expulsion would go forward. I think there is an automatic stay if they timely appealed, which I think they did. So anyway, I think that one way or the other, the Supreme Court's going to decide that case. I just don't think it's going to decide it now. It might decide it in the future. And you remember, or maybe you don't remember, I think that Alpine are, amongst the biggest scumbags in the securities business. They had so many violations that they were found on. I don't know the number they weren't found on, and all kinds of conduct that was ridiculous, reprehensible, and somehow the SEC and FINRA never has gotten rid of them to this date, which makes no sense also, since they've determined that they were a risk to the consumer. So if they're a risk, but they let them continue to act. Yeah, let me ask you that question. What do you think about that? So if the government says that if you do X, Y, and Z, it'll be a super risk to certain people's interests, but nothing is done to prevent that. I would have hoped that maybe the SEC or FINRA would have jumped in, but they haven't. They let this nonsense continue. But anyway, Alpine continues to exist. They supposedly are the shorter, or had a concentrated short position. I know people have asked because they see it trading. I think it trades in GTII now, trades in Canada, and they see it trade. I think last 3 months, the share average is 28,000 a day approximately. And that's probably mostly from Canada, I think. And, if it's trading, I mean, of course, we don't want it to trade at all. And I brought it up, or it's been brought up and communicated to the receiver. They may even reference it in the report. It's difficult for them to get a handle on. It's not in huge numbers. And if it's really shorted, the number that some people believe, then, 28,000 a day, it's annoying, but not material. But I know the fact that some people can trade it is annoying to us all, because I can't trade it either, nor would I, because I was a plaintiff and agreed to lock up my shares. Some people said that, by the way, the plaintiffs in the Vegas action. Some people said that they asked, or the receiver told them that they don't have to have their shares locked. I don't know if that's true, but I don't know how you would, if you're in U.S., I don't know how you would trade it anyway. So that's kind of interesting on that. So I think we're getting close, kind of to summarize. I think we're getting close to the end of the period when the documents that we need will be filed and in play. That doesn't mean that we will be done, but we will be done with kind of all the stuff that we will have needed. And then ultimately, it probably has to be an exchange. It has to be, it has to agree to something. There might be other conditions. But once that audit is signed off on, the two motions are heard and granted as I expect them to be in some form. I think, a lot of the conditions that we needed will have been completed. And I think if they are completed, then that would be AIversity would be very pleased with that result. Although again, I don't speak for them in any way at this point in time. So I think we have, and this week, by the way, I didn't know if I was going to get the receiver's report. I didn't know about the motion draft, and this has been going back and forth. So at some point in time, and that's why I think I left it ambiguous, because I didn't get the receiver's report till today. I didn't know about the draft. Actually, the draft motion had been done today. So that's why it was ambiguous, because it was ambiguous. And I think to some degree, got to pat myself on the back. I do think that the fact that we were doing this today and the fact that I'm being a pain in the ass does speed up things. I know that the Receivers Council and I had a kind of a chuckle, because when you do this kind of work at time and you're interacting with somebody, sometimes those interactions are kind of like somewhat sharper than normal in a modern society. So we both kind of laughed at that. And that means, like, sometimes when lawyers are communicating, it's not always super pleasant. And there's sometimes an edge. And there's, listen, again, people have different views, different interests. And that's where we go. But it looks like we're making progress. And again, I'm expecting the motion to be filed very soon. And I think once that's filed, that will also give some, again, I'm not speaking for them, but I think, if I were in their shoes, that would give me some, make me feel good feelings if that stock motion was filed. And so I expect it to be filed very shortly again, but prior to the 27th of May, when the next hearings are in front of the court in Las Vegas. And again, I will be attending that hearing in person. So that's it. So let me summarize again, a bunch of yada, yada, this and that. And then some more of that. And then talked about the report a little bit, about the motion regarding shares, about the status conference in court on May 27th, 28th, about the audit, waiting for some attorneys to sign some certification, if not the court intervening, about Alpine and the Supreme Court, last but not least, the trading. So the receiver is aware of the trading. They don't have any control over that, but they're looking at it, and to the extent it is ridiculous, or they're able to find something, they will. I've heard anything, because people ask me occasionally about this. I've not heard anything about the dividend or what they're doing about the dividend. I don't think it's on the top of the list. I think the issues that we mentioned are fundamental to going forward with the deal. And then once those are done, then you could tweak whatever else needs to be done. So that is it, except we will go over to, hopefully that clarifies where we are. And that is progress, since before today, the receiver's report didn't exist. There wasn't a draft of that motion. Didn't know about the audit specifically, and those things had changed. They literally changed over the last day. So that's good. That's good progress. And again, hope to be a pain in the ass to move things forward. Thank you all for watching. Whenever you're watching, I'm going to let you go now. Join us tomorrow night, JR and I. We're going to go over the wonderfully exciting receivers report. We'll discuss that in length, because how else are you going to discuss it? And if you want to join us tomorrow night, 7 p.m. Eastern, same bat channel, same bat station. Thank you all for joining. And so that's it. If you have questions tomorrow night, let us know. And JR is really good with his right eye, and so he should be able to answer a lot of those questions. Anyway, thanks all. And I know today, like, some people said it wasn't trading. I don't know if that was the case. I know on Yahoo, it showed it had traded. So this is referring to GTII. To everybody out there, be well. We'll see you tomorrow night, hopefully. Have a great Friday evening. Enjoy yourselves. Be careful. Drive safely. And take care.